Hello, hello, everyone, and welcome to In Time. My name is Nicholas Lamar Soutter, and with me, as usual, is Courtney Stewart. Courtney, how are you?
I'm doing good. I got a cat here.
No, when don't you have a cat? From now on, we're all going to assume that she has a cat, and only when she doesn't is she going to actually uh, let us know.
I mean,
Well, so this
that's
is
fine.
today we are starting our um, series on American civics, and we decided we wanted to do this. I think, yeah, well, I think we've had Landon on a lot, and I think he's been very educational on a great many things, but we thought it would be a good idea to give a lot of what he discusses with us some form and to sort of be able to do it really from beginning to end. And I think if anyone's interested, the past videos that we've done on a lot of the politics, certainly on um, elections, on the impeachment process. I think all of those have been very interesting, but I think we wanted to do something a little more formal. So we now have our American Civics series. It is going to be every second Thursday at 9 p.m. This one's just having a little off, but they will be continuing every second Thursday
Eastern.
at 9 p.m. Eastern Standard Time. So uh, this week, we will be starting with the Constitution, and we'll be learning about how and why it was made and the ramifications today. And we've got a lot to discuss. So, without any further ado, let me bring Landon out. And Landon, there he is. Landon, how are you?
Good morning, good afternoon, or good evening, depending on your time zone and latitude. And hello from your friendly secular astronomer. It's great to be here. Good to see you, Courtney. Good to see you, Nick. Hope you're in fine fashion and your cats are appropriately situated.
Oh, never.
So we decided we'd start with the Constitution. I think that's a great place to start. So, Landon, what can you tell us about how and why the Constitution came to be?
Well, I mean, let's start by the fact that after the colonies won the revolution with the help of people like France, um, we put forward a first constitution that was ratified in 1781 called the Articles of Confederation. But you might say that we started off with just the the colonies being more like a loose confederation of actual states or operating more like independent countries. The national government was comprised of just a single legislature, the Congress of the Confederation. There was no president, there was no judicial branch. Um, they really didn't want a central power figure. I mean, they just overthrew King George III and weren't really interested in having some sort of monarch ruling over them. And the problem is that these Articles of Confederation gave Congress the power to govern like foreign affairs, conduct war, regulate currency. However, those were sharply limited because Congress had no authority to enforce it or to raise money. Um, so, in fact, the states could just basically say, "Yeah, the Congress, that's convention Congress, that's nice, but we're not going to pay for it." The Congress could say, "We want to do this," and the states could say no, and some states could say no, and the other states would say, "Well, why would we have to pay for it if they're not going to pay for it?" And so it really was fell apart. Part of the problem was that in many cases they had to have effectively unanimous consent of the states in order to get something done, and there was always somebody that was willing to object. So it was the Confederation, Articles of Confederation were a mess. Now there is this big balance. There's this big argument that's been going through the history of the United States for a long time of whether or not things like states' rights, whether states should determine what goes on, or the federal government should go what's going on, and that echoes even to this day.
Mm.
Um, but it did they there was basically sort of this notion of like, well, okay, we need to fix something because we can't govern. And in particular, there was a bunch of things where they needed to raise money and raise taxes because they incurred large debts to fight the American Revolution, and they needed to pay back money, right? And they needed a stronger central government to remain stable. It was just untenable. So in 1786, Alexander Hamilton, which was a lawyer and politician from New York, called for a constitutional convention to discuss the matter, right? To see how the Articles of Confederations can be fixed. And so the Constitutional Convention actually opened in Philadelphia, Pennsylvania. It's in a place now known as Independence Hall. Actually, that's where the Declaration of Independence initially was signed 11 years prior to that. And there were 55 delegates in attendance, right, representing all 13 states except the state of Rhode Island, which refused to send any representatives because it did not want, Rhode Island did not want any powerful central government. So they essentially said they're not going to participate. George Washington, the national hero of the Continental Army, was selected as the president by the Convention for a unanimous vote. He initially was reluctant to actually get involved because he was focusing on his estate in Mount Vernon and just wanting to retire. But they convinced him to come in. So the delegates are now known as the framers of the Constitution. They were basically an educated group of merchants and farmers and bankers and lawyers and so forth spread out. But you might say they were upper class and upper middle class of the time. And
so rich white people is essentially what you're saying.
Yes, and rich white men too.
Yeah, okay.
Yeah, I was going to say people.
Yeah, thank you. That's a good correction. Yeah, so basically, obviously, it was olden times. Things were done so differently back then.
Oh, so much differently.
Yeah.
But I mean, I'd say that certainly that the Continental, but many had served in Continental Army, had served in the Continental Army, had been in legislators, had worked. I even served in the Congress of Confederation. And there were Protestants. Most of them were Protestants, but they were 8 of them actually were signers of the original Declaration of Independence. So there were people who were there. I mean, they had people like Benjamin Franklin. He was the oldest person, 81 at the time. We also had, but there were political leaders not in attendance, like for example, Thomas Jefferson and John Adams were serving as ambassadors in the U.S. And John Jay and Samuel Adams and John Hancock were absent from the convention. Patrick Henry was chosen, but refused to show up because, again, he didn't want a central government, right? So some of the big founding fathers didn't want to participate in it. But another thing that happened was that the reporters were banned from the convention sessions. They were held in secret to avoid outside pressures. But James Madison from Virginia kept a detailed account of what transpired behind closed doors. And in his papers, his widow, Dolly Madison, yes, that Dolly Madison, sold some of the papers, including his notes on the convention debates, to the federal government for some of $30,000 back in 1837.
Jesus.
So that was a fairly sizable thing. So a lot of what we know about what happened in debates came from Jane Madison's very detailed accounts. And the debate was really quite. They said, okay, we're here to sort of fix Articles of Confederation, but pretty soon people figured out they're not fixable. They're fundamentally broken, and so we need a new.
Let me interrupt. What was the most broken part about them? I mean, I guess so. In part, it was because nobody, just one person could just override everything. So it was too.
Yeah.
It was too decentralized. Is what it sounds like.
Yes, and that the Congress had the power to do something, but not the power to enforce it on the states, and not the power to actually tax or raise money. So you could sit there and say, okay, we're going to pay off this debt because we promised these people who fought for a revolution that they get their money back. Let's pay it back. So states, pulling out the money, and states could say no, right? There was no way the federal government could actually force the states to pay anything. And then if one state said, I'm not going to pay for that, then the other states would say, well, why should we pay for it if they don't, right? And so it would just, nothing really got done. It is a debate that we see today where there's some people, there's a famous person, a so-called conservative, who said he wanted the federal government to be small enough that it could take it and drown it in the bathtub.
And who was that again? It was. I know. I'm going to kick myself that I don't remember who it was.
That'll be that'll be one of the and there's people here now. That'll be one of the quizzes of who said that.
Oh, okay. My bad. I'm stepping on it. Okay, but yeah, I'm trying to remember. Okay.
Let's see. That's a homework. Who said that? But this debate over central federal power versus states' rights has gone on for a long time. I mean, the Civil War was about that, and even today, over how we're responding to the pandemic is a big states versus federal government thing. So as I said, other contentious issues were, how the legislature is going to be represented. Large states that time, the large as in population, like New York, said, well, we're much bigger than a small thing like Delaware or a small population in South Carolina. So we should have more say, because it should be, one person, one vote. But other states that, like New Hampshire or even, Rhode Island, who was in there, would have said, hey, we count too. We just don't want the thing being run by the three biggest states. So how do you handle the big states being most of the people?
Yeah.
Majority rules versus, but everyone needs to have a say. And so it was resolved by the Connecticut Compromise, which had a bicameral legislature where we had a House and a Senate. Another controversial topic was slavery. Some northern colonies had already started outlawing slaves, whereas southern states was an issue for individual states to decide it should be kept out of the Constitution. And that was a big thing, in fact. And they even went to the point of saying, well, but okay, but you've got all these slaves. Are they considered citizens for purposes of determining how populous your state is? And so they came up with we'll call a slave to be 3/5 of a person as a compromise, right? It was eventually ratified in September 1787. And there was a committee basically of people like Governor Morris and Rufus King and so forth, put together a process. They started off with 4,200 words, and George Washington actually was the first person to sign the Constitution. Out of the 55 delegates that actually stuck with it, only 39 actually signed it. And some had already left Philadelphia. 3, Mason, Edward Rudolph, and Edward Gary, actually refused to approve the document. But way it was, according to the Constitution that time, in order to be ratified, it had to be ratified by 9 of 13 states. So Madison and Hamilton, with the assistance of John Jay, started writing a bunch of essays, 85 essays in all. And these are called the Federalist Papers, right? Arguing about the need for the Constitution and published under the pseudonym was Latin for public. Pluribus.
You said how many articles were there?
85 essays were in the thing, and these are called you'll hear they're called the Federalist Papers, right?
Apparently, Hamilton wrote 51 of them.
Yes. Yeah. And other ones are assistance from John Jay and other people that added, but there was an argument over why we needed a Constitution, and so so December 7th, Delaware became the first state to sign it, followed by Pennsylvania, New Jersey, Georgia, Connecticut. And then there was a big problem because there's a number of states like Massachusetts opposed the document because it said, look, you've made a constitution that gave power to the government. But what about the people? Right? You set out all these rights on the government, but you're failing to remember we had a revolution because of the people, right? And so it stalled after you only had 5 states of the 9. It stalled in there, and put up a constitution. So what came about was they said, okay, we will have a promise that very early on, we will table a series of amendments to add to it. And they were called the Bill of Rights, right? It was going to be a set of amendments to the Constitution. And the problem is we're going to do that first thing. And so then Maryland, South Carolina, and New Hampshire became the 9th state to sign it, and it became law. By the way, Rhode Island, the last holdout, finally ratified the Constitution in 1790, a year later. So this Bill of Rights came about. Madison, who is now the member of the newly established House of Representatives, introduced 19 amendments to the Constitution. Congress adopted 12 of them, and 10 of them were actually ratified and became known as the Bill of Rights. So that's kind of a little brief overview of stuff. There's been, by the way, thousands of amendments, and we'll get to amendments and so forth today, but it is essentially, that's sort of how we came about, how we got the Constitution in the first place and why. So comments on that so far, or observation before we go into what's in it?
Oh, so no, I was going to guess Grover Norquist for the one who said that he wanted government small enough that he could drown it in the bathtub.
I believe you are correct.
I'm sure I am correct, and I'm sure I did not get that from anybody in the live chat. That is totally me.
But I also will point out that Trevor Lund was prescient and anticipated your answer.
Yes, he did. Thanks. Shoot. The comments just went private for members. I guess certain smarmy hosts will no longer be able to see said comments. Anybody who would like to pass any information to me along, just go right ahead. I'm good.
So the debates about the Constitution, about the form of government, I understand had been going on since the Revolution. And just because one side wins doesn't mean that the debate settled. We had the issue about slavery, that a compromise ended up being one of the factors in the Civil War, but effectively there was the so-called Confederacy decided that they were going to leave the Union, and under the Constitution, that was not constitutional, but they didn't care. And so part of the whole whole Civil War was really fought on who has the power.
Well, let me interrupt for 1 second, and I don't want to. If this is jumping ahead, we can postpone it. But it doesn't say in the Constitution that you can't leave.
Yes, but it doesn't give the process of how to leave, right? So the notion of the way that we interpret it is to say that Congress has the power to establish states, and so therefore one would assume that Congress has the power to dissolve states or remove states.
Well, if it doesn't prohibit people from leaving, would that not necessarily entail that then they could leave?
Well, there's no process by which can be recognized that they can leave.
Okay, so since there's no recognition of it, then the state could say they've left, but it's not. There's no way to recognize it without Congress.
If you're part of the union and the state government says this, but the rest of the union says that, who pun intended trumps who?
Well, according to the Constitution, the supremacy clause, but if you're not recognizing the Constitution.
Yes. Yeah. So let's actually talk about the Constitution, and it's something I would encourage people to sit down and read. I mean, I'll go over what each section is just briefly, but I think it's important for you to sit down and actually read the Constitution. It's a small enough document that it's not going to take you too long to read, but as we will talk about, it has significant impact on you and your fellow country members. So some people in civics class are forced to memorize the preamble or something, or the more perfect union thing. But I think that it bears in mind a good thing of reviewing the Constitution. The Constitution is formed with 7 articles and then a collection of amendments. Today, there's 27 amendments, right? So 7 articles and 27 amendments or alterations, right? And so the Constitution starts with a preamble that some people read, but in Article 1 establishes the 3 branches of government that we have today: the legislature, for example, establishes the House of Representatives, and Section 1 is about establishing the legislature of being a 2-party body. Section 2 talks about the Constitution. The Constitution talks about the House of Representatives and age limits and things like that. Section 3 talks about the Senate, establish minimum requirements such as you had to be 30 years old, and originally you had to be appointed by state legislatures. Section 4 talks about methods that each state may establish the methods for selecting members of Congress. Section 5 talks about that Congress must have a minimum of 2 members present in order to meet. You just can't have 1 person. That's an interesting thing.
So
about quorum.
Okay. Well,
a minimum number. Minimum number. I should say minimum number of members present in order to meet.
Yeah. Okay. So the original quorum was 2.
Not 2. I'm sorry. I misspoke. I said you had a minimum number to meet.
Oh, right? Okay. Yep.
But it also set out fines for members who didn't show up. So you couldn't just sit there and say, well, I'm not going to meet and prevent Congress from operating. You were fined if you showed up. And he also had, and Congress could actually expel members, allow people to keep a journal, the congressional record, and also said that neither the House nor the Senate can adjourn without permission of the other.
Oh.
So House of Representatives, Senate can't sit there and say, oh, we're going to adjourn. The House says, no, we still have business going. So they both have to agree to adjourn. Section 6 says they get to be paid and that they cannot be detained while traveling to and from Congress. They also can't hold any other office. So if you're a member of Congress, you can't be a mayor or you can't be a diplomat or so forth. You have to only be a member of Congress. Section 7, a real big thing we'll probably go over later on, is how a bill becomes law. And that things like money, bills for raising money, such as taxes and fees, have to start in the House. Bills must pass both sections of Congress, those sorts of things. The whole bit about the veto is in Section 7. Section 8 of Article 1 talks about this very specific powers that Congress had, including to establish and maintain an army, a navy, to establish post office, hint, to create courts, to regulate commerce between states, to declare war, to raise money. These are sorts of things. These include something called the Elastic Clause we need to go into a little bit later. Section 9 places limits on Congress, such as in certain legal terms, such as suspension, that Congress can't suspend habeas corpus, can't do bill of attainder, can't do ex post facto. This is basically something saying you can't pass a law after the fact. You can't and other matters, right? They also can't give preference to one state or the other. You can't sit there and say everyone but California has to do this, right? Another big thing is that no money can be taken from the Treasury except by law, right? So you just can't dip into the Treasury whenever you want to. The Congress authorize it. Another one is that no title or nobility, such as prince or marquis and so forth, will ever be established by government. So that's why U.S. doesn't have any dukes, doesn't have any knights, doesn't have any of that crap, right? None of that royalty bullshit, is allowed
by law.
By the Constitution, right? That's one of the reasons why I did not refuse to, when I was mayor, acknowledge the spawn of so-called Queen Elizabeth when they wanted to come to the city, right? We can't establish it, and I think we can't pretend like that's there.
So we can't recognize it. And wow. Okay.
mean, that's how I interpret it. Now, they could have come and I could have given due respect as a member of the government, but not sit there and kneel and swear arms and so forth. So why you can't be, as an American citizen, it's not legal for you to be knighted, even though some people can be honorary knighted, but that's a different story. Anyway, Section 10 prohibits states from several things, like state cannot make their own money. That was one of the things that happened during the Article of Confederation. Each state had its own money, and then certain states would take money from other states, and they establish exchange and say, well, your state's not any good, so you have to give two of Massachusetts dollars for every New York dollar, for example.
Yeah. Okay.
So states cannot own money, make their own money. They cannot declare war. They can't do most of the things that you give Congress the power to do. They cannot tax goods from other states. They can't have their own, and they can't have their own navy. So California could not say all of these filberts from Oregon are going to have this tax. That can't be done. So that's Article 1, right? Basically establishing the three branches of government. So let's go on to Article 2. So Article 1, really the first article is about the three governments, is focusing on the legislature, right? So we saw the House and Senate, what they can do. Article 2 is establishes the second. So Article 1 establishes the first branch, the legislature. Article 2 establishes establishes the office of president and vice president. It talks about electoral college. It talks about the president having some of the most powers, being commander in chief of the armed forces, has a cabinet to aid him. He can pardon criminals. He can make treaties with other nations, but Congress has to ratify it, and it has to be approved ratified by the Senate. It also, Section 3 establishes the duties of the president, such as State of the Union address, making suggestions to Congress, acting as head of state, receiving ambassadors, those sorts of things. Also, the fact that he has to make sure the laws of the United States are carried out. And that's been a contentious issue because sometimes presidents have used the process of benign neglect that was Nixon's phrase for when Johnson's Civil Rights Act occurred. Nixon didn't want to do it, so he decided to deploy the tactic of benign neglect when enforcing some of the civil rights laws. Yeah. I mean, I picked Nixon, but let me give you a hint. Every president since George Washington has been accused of cherry picking which laws they enforce more vigorously than others. That's nature. Section 4 of Article 2 talks about how to remove the president through impeachment. So that's the thing. Article 1 was the Congress. Article 2 is about the president, how the electoral college, how they're done, requirements for president, oath of office, cabinet, pardoning, duties, and impeachment. So well, we're going to do a little bit later, but effectively, each state has one vote for each member of Congress. And those are the votes that are used to establish who gets to be president, who gets to be vice president. So rather than having, remember that big compromise, the Connecticut Compromise about the House and Senate. Well, small states were worried that if the president was elected by popular vote, then they'd always come from a big state like New York or Virginia. That those states would not only rule Congress by sheer number of members, but they would also effectively by fiat select who gets president and vice president. So they said, okay, the president and vice president has to come from two different states. They can't come from the same state. Got to spread it around, and we have this process, the electoral college, this thing where the number of senators plus representatives is a number of electors you get, and you, the state, figure out how you select those electors, and they went and go and vote as to who is president and vice president. Right?
All right,
They did
perfect.
not. The small states feared popular vote.
Yeah.
So let's go on to Article 3, which establishes the last of the three branches, the judiciary, right? Establishes the Supreme Court as the highest court in land, right? That was a big thing because the Articles of Confederation didn't really have ability to force things, right? And it said that the Supreme Court has power over lower courts, and they can serve for life as long as you're on good behavior, which essentially means for life. It establishes the kind of cases that can be heard by the federal judiciary, which the Supreme Court may hear first, right? Establishes the Supreme Court as the that other cases can be heard by the Supreme Court by appeal. So some cases Supreme Court can pick up directly, some cases by appeal. It guarantees also guarantees a trial by jury in a criminal court. That's actually on there, and so it also Section 3 defines very explicitly what the crime of treason is. So somebody who has been talking about blah, 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 treason, blah, 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 they usually say, Mr. President, have you read Article 3, Section 3 of the Constitution you swore to uphold? Because that does not sound like there's a very, 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 very specific definition of what treason is.
Wow. That's
All right.
interesting.
That whole thing about treason. Remember that the revolution was not a democratic action. Most of the colonists were loyal to King George. If you had a
something
vote,
like 80%, if I recall, 80% were still loyal to King George.
Yeah, so that's one of the ironies about that. People say, well, it's democracy, blah, 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 the peaceful rule. Well, the revolution was not a big uprising.
A majority.
It was a minority that had the power to enforce it. So there were problems with for people fearing that if the royalists and the King George sycophants and the people that go gaga about all those silly people that pretend to be appointed by God to rule got a hold of the government, they could turn around and basically say, Your Majesty, please come and rule over us, right? So it talked about treason very specifically. That's why, for example, the president had to be somebody born in the United States,
right?
Not someone who arrived there. Those are things like that happen.
So is that why so that they would not? Wow, that's interesting.
They were feared somebody coming over from England, becoming popular, passing a lot of money, getting themselves elected, establish themselves as effectively a king, establishing dukes and so forth, and then swearing allegiance to the crown.
Wow.
Also treason. There were also others. We had other rebellions going as well. So that treason was a very big thing at the time. So let's move on to Article 4. It concerns the states.
Just one comment.
Sure.
I know we're trying to move through it and then comment, but I just feel like that's such a good point of why this is so important to learn for especially young people, because people tend to think that a government like America or England or France or something, that they're so established and that they are unchangeable, and so it not only means that they are changeable, it also means that they're fragile, that there's a lot of different ways that this could have gone, and there are a lot of different ways it could go in the future, so you can't take the stability of the government for granted. So anyway, go ahead.
There's a story that a lady after they knew that the Continental Congress was meeting in secret, what the details are, and when they sort of adjourned and said, okay, we have this constitution to be ratified by the states. Benjamin Franklin leaving was asked by a lady, so what do we have? Because all these rumors about what they were doing.
Right.
What kind of government do we have?
Mm-hmm.
And Benjamin Franklin was rumored to return back and say, ma'am, it is a republic if you can keep it.
Right.
So Article 4 concerns the states, right? It mandates that states will honor laws of other states.
Okay.
This ensures, for example, that a couple married in Florida will be considered married in Arizona.
Mm-hmm.
That someone convicted of a crime in Virginia is considered guilty in Wyoming.
Mm-hmm.
And that's been a big issue because when you have states like California recognizing gay marriage,
right,
the Constitution, Article 4, Section 1 says, hey, other states have to honor it.
Right.
And
so legally, I guess they were supposed to have already, because they're supposed to respect what happens in other states.
Yeah, and so that's been an issue because on the other hand, you could have states passing what was unconstitutional laws, because you could argue on the other side that a particular state had laws saying that Black people could not vote, Black people could not own property, Black people could not go to white schools, right? And so does that mean that other states have to honor that? So it's complicated, but that's essentially what the Article 4, Section 1 is the sort of the clause that talks about states honoring laws of other states. State 2 guarantees that citizens of one state will be equally treated like all citizens from another. So a person computer crime in one state flees to another, they have to return to the state where they fled from. Right? So just going across state line doesn't mean you can escape stuff. There's effectively extradition between states.
Yeah.
This also means that, for example, but issues such as, let's say one state decides that it is still too dangerous to open up widely to a pandemic, and another state says, go nuts. Have orgies, have rave parties, have big rock concerts and monster truck pulls, all this sort of stuff.
Let me interrupt. Which state said that? I just hold on. Do you have an address? I'm just asking.
And so one state says, well, okay, that state opens up and we're locked down, so you can't come in from that other state. Can't do that. According to the Constitution, you have to be treated fairly, right?
You have to respect the laws of the other
citizens of one state have to be treated fairly like citizens of another, right?
I see.
Also deals, so the article, by the way, there's an article also that dealt with fugitives, slaves, and how they had to be returned with what other things are stuck in there, and that's of course been struck out. Section 3 concerns the admittance of new states and control of federal lands. So this is an issue you're talking about of that's where you can get into debates about whether or not states can leave as well.
Right.
But of course, the Amendment actually nailed that thing in the ground. The Confederacy lost. Their treason did not stand, and the federal government remains allegedly supreme, but things happen, right?
And Texas still talks about seceding a lot.
Yes,
well,
they do.
That's a common bit. But so Section 3 of Article 4 gives how new states come in and how federal land is controlled. So Ted Bundy should look at Article 4, Section 3.
He loves his country too much to read the Constitution. He's too busy loving it.
Section 4 ensures a representative form of government, representative democracy, right? And it as opposed to a monarchical or aristocratic scheme, right? states derive its power from the people, not from the king or from the gentry stuff. So it guarantees the federal government will protect the states against invasions and incursion, and as well. So there's some important stuff in Article 4, Section 4.
And I would also say that Bonnie and Clyde also ignored that law.
Yes,
And
that's
they
also
really
tradition too.
took advantage
Yes,
of
yes.
that.
So Article 5 deals with methods of amending or changing the Constitution, and that's a very important article.
Yeah.
To look at it, sort of, because the Constitution, they said, was meant to be the Federalists said, a living document.
A living document.
Remember when you had the 5 states initially said, hey, this is pretty good, but it ran into trouble because people said, you got all this power for the government, where's the power for the people? And so Article 5 was how to amend or change it. And particularly, they promised that one of the first things they would do would be to propose a series of amendments. Article 6 concerns the United States itself, right? It guarantees the United States, under Constitution, would assume all debts, contracts, and entered by the United States under the Articles of Confederation. So people who owed money from the Revolutionary War and things like that, the federal government could settle those debts. The Constitution, its laws, and treaties of the United States will be supreme law over the country. So here's another case where the treason of the Confederacy was wrong because the Congress said, because it talks about how to establish a state, talks about Congress having the power to enforce that legislation, and Congress said no on this sort of thing. So, and it required all officers of the United States must swear an oath of allegiance to the United States and the Constitution when taking office. Article 7 deals with methods of how it's ratified, how the original 13 states would that 9 had to be accept the Constitution to go into effect. So you think of if 8 establishes the supremacy of the United States first, then Article 9 talks about how it's ratified. So those are the 7 articles. Now we had a first 10 amendments. Originally in 19, Congress accepted allowed for 12 or took 12 and 19 under consideration, and 10 were ratified. So let's just briefly go over the first 10 amendments, if you will. First Amendment, big one, protects the right of the people to practice religion or not, to speak freely, to assemble, meet, to address, petition to government, and the right of the press to publish. And by the way, there's a lot of debate about whether that should be one amendment or several amendments, but they thought it was so important. Everyone wanted their most important thing that they decided to put a catch-all of every, some of the big things in one. Of course, when it did that, number 2 sort of said protects the rights to own guns. Now, there's a debate whether that right protects the state or protects the individuals, and that's a debate that we can talk about.
I foresee another. This is part of a series. As a reminder for anyone who's just joining us, this is our first episode of the series.
We're not stopping here.
I have a feeling that one's gonna be a whole.
I'm trying to be in some ways a little bit neutral, although you can probably tell that I consider my relatives who fought on the side of the Confederacy to be traitors, and the relatives that fought against them to be heroes. So the Confederacy can go pound sand. They lost and they're defeated, but by the way,
excuse me, they won. And
by the way, it turns out that the issue about treason, that essentially you could have had essentially mass treason trials against people in the Confederacy, and you could have had basically a wholesale slaughter of stuff. But one of the things that Lincoln was able to do before he was assassinated was that the malice towards none precept of essentially saying no, we're not going to go and punish the Confederacy for its treason. Now, the problem was that when he was assassinated, Vice President Johnson, his vice president was from the Confederacy. Vice President Johnson was probably maybe the Trump equivalent of the 1800s.
Whoa.
He was bombastic. He was known to hold rallies. In fact, part of his why articles impeachment was that he would actually hold mob-like rallies in front of the Capitol steps, railing against what the Congress is doing, disrespecting Congress, right? So he was impeached. He was tried by the Senate, and he escaped being removed from office by one vote. Senator was actually brought in on a stretcher from the hospital, was ridden up by his doctor to be able to cast his vote and save him. So,
oh my gosh, that's so dramatic.
so just
I
because you think
so
today is, we've never been unprecedented. I tell you this, for every weird thing that's happening, every bombastic thing, every bad thing you see happening today, you can find bad, if not worse, in the past. So
I'm going to interrupt though, and just a quick correction. The Confederacy won. I took a look at the map of voting in the U.S. and found that most of the Trump voters were south of the Mason-Dixon line, and my belief is that, frankly, they won, and our punishment for losing was to be stuck with them. I'm inclined to reverse that decision and say they can head on their merry, but I guess I'm alone.
And in some ways, some people say, well, okay, what happened was that it was not one, but to say, well, they may have taken over the let's say the Republican Party or the conservative parties, but you have to understand that was not always the case. Originally, the Confederacy, the Confederate states and state senators were solidly in the Democratic Party, known as Dixiecrats. And when Johnson passed landmark legislation about the Voting Rights Act and the Civil Rights Act and the Fair Housing Act and some of these other things that really established the things from the Civil Rights Movement, there was a process called the Southern Strategy, where effectively, and Johnson knew this. President Johnson, Lyndon Johnson, not the other Johnson, knew this. And in fact, he made a comment in signing the Civil Rights Act into law. He said, and there goes the Confederacy, right? And in fact, what happened? Many of the Democratic senators, the Dixiecrats, who were staunch segregationists, flipped and became Republicans. And from then on, the Republican Party had a lock on the South. And that's sort of continues this day. Again, so this debate is not over.
this soundbite that just happened, I think us millennials are going to have to back that up and repeat it, because that is a very important thing that is being very mischaracterized by a lot of people. So that's important to know.
Yeah. So moving on, the Third Amendment guarantees the Army cannot force homeowners to give them room and board. And by the way, Nick, I'm one of the few people in the United States that have actually sued over the Third Amendment.
Of course you are. How does that not surprise me? Mister, I've been inside a volcano while mountain climbing upside down underwater at night in the dark, in the fog.
The attorney about advice, because you go to your lawyers for help and stuff, and I said, tell me about the precedents, about the case law, this thing, because I remember the Constitution. She said, well, she took me to the library, and she said, here are all these books on Supreme Court cases of the First Amendment. And here's a small section of the Second Amendment. And by the way, if we open up the book on the Fourth Amendment, there's this little page here talking about the few times that someone actually sued over the Third Amendment. So Third Amendment is can't quarter troops. Fourth Amendment protects people from the government improperly taking property, money, papers without a valid warrant or probable cause. Good reason. Fifth Amendment protects people from being held for committing a crime unless they are properly indicted.
What does that mean?
That is you have to bring charges.
Okay.
Right. You have to say you've done this, right?
You can't hold someone forever. You can't hold someone forever without bringing charges against them. You have to either let them go or
It also says you may not be tried twice for the same crime. So if you get tried, jury says you are find you not guilty, you can't sit there and say, let's try that again, see if we can get a different jury, different answer. You also it says you cannot be forced to testify against yourself. They can't use torture to torture confession out of you as an example. And you can't have property be taken without being compensated for it. It guarantees so-called due process. Fifth Amendment, big thing. Sixth Amendment guarantees a speedy trial of an impartial jury. That the accused can confront the witnesses against them. You cannot have people testifying you in secret, which is almost true. This is one of the things that was really I saw that was really insidious in the South Africa in the era of the apartheid government was that people would essentially testify and behind closed doors, and you couldn't actually confront your accusers and say, well, how do you know? Or no, you weren't there. How do you know? Right. So Sixth Amendment also says you must be allowed to have a lawyer. Enough, the Gideon versus Wainwright, we'll talk about that case.
That's
even though it's in the Constitution.
It doesn't say that. It doesn't say that, Landon. You know that as well as I. It doesn't say that.
But it says the accused must be allowed to have a lawyer, but they don't have to have. That is, if you have a lawyer, the Sixth Amendment says you can use a lawyer, but it doesn't necessarily guarantee that you could have a lawyer. In fact, if you can't afford one,
you're SOL. We'll do Gideon too. That will be another. We will do a whole episode on Gideon.
Thing of but we do. You have someone appointed, right? That's in the Miranda rights.
That came about. The Miranda decision was a decision by the Supreme Court. Talking about the Sixth Amendment, right? In particular, and the 14th Amendment, right? So
originally that wasn't the case. That if you couldn't afford it, then you weren't.
Well, those are two different. It's in the Constitution doesn't mean it gets enforced.
Right.
So the right to an attorney is an interpretation of the Constitution that Gideon, the Gideon case, when he lost, he appealed to the Supreme Court, said, I didn't have an attorney, how could I possibly win? And they said, yes, in fact, the Constitution does grant this. It's not explicitly stated, but any reasonable interpretation is that you should be entitled to an attorney. And then Miranda was another decision where they said, well, you should have, not only do you have the right to not talk, you have the right to be an idiot and not realize that you have that right. So officers are required to tell you that you have the right to an attorney and you have the right to not say anything.
Yeah.
Right. Reading the Miranda rights.
Yep.
Just because you have the right to have a lawyer doesn't mean you can get a lawyer. Doesn't mean that you have a lawyer in effect during your whole process from arrest through trial and imprisonment as well. So Seventh Amendment talks about guarantees jury trials in federal civil court cases. But it's no longer, this kind of case is no longer heard in federal court, but it's a jury trial for civil cases. Eighth Amendment talks about guarantees that punishment will be fair, not cruel, and there'll be no extraordinary fines. You can't fine someone for not wearing a mask $1 trillion and put them in jail until they pay it, and force them to sleep on hot coals and that sort of thing. Right? Those are.
So if somebody recommends a lethal drug just off or potentially lethal drug, say hydroxychloroquine or something like that, that people should just start chugging the pills because it might work. You can't string him up by his toenails and hang him up over a pit of piranhas or do anything like that.
Yes,
Shoot.
that's true. And you can't force someone to say, well, you didn't social distance, so we're going to pump you full of hydroxychloroquine. That would be considered potentially cruel or unusual, right? So cruel, unusual, large fines, that sort of thing. Now, Ninth Amendment simply states that that you know that the other rights that the other rights may exist. Just because they're not listed doesn't mean they can't be violated. That's a big thing. That if you said, well, the Constitution does not guarantee you the right to use the internet because it didn't mention internet. Ninth Amendment says just because they don't be listed doesn't mean they don't exist and they can't be violated. 10th Amendment, the other thing that's actually subject to debate, and we'll have to go with this, essentially states that any power not granted to the federal government belongs to the state or the people. That's a big thing. So now you sit there and say, well, the Constitution doesn't talk about the use of the internet. So that's a right that's belongs to the states or the people. That the government can't regulate the internet. Well, actually, they can because of other clauses, right? So with the Bill of Rights, 11th Amendment basically says that the original jurisdiction of the Supreme Court concerning a suit brought against any other state by another state, right? And by state by a citizen of another state. So this is basically how that Supreme Court is. If you bring a suit against a state by a citizen of another state, like if you want to sue the state of Utah and you live in the state of Nevada over what the state of Utah is doing, the Supreme Court is the place where has the original jurisdiction. But Utah would say, "Hey, Nevada citizen, you're not a Utah citizen. Go pound sand." Well, it says you can sue us across state lines and sue other states, and the Supreme Court is the place where that's heard.
I've never heard that term. Go pound sand.
It's an effective means to tell somebody off.
So there's a chat. It's not a super chat, but I think it merits reading. Trevor Lunn for $0. I live in the hopes that the White House chief medical officer instructed Trump to self-administer those hydroxychloroquine tablets as a suppository.
I'm told that suppositories are a way to rapidly get a drug into your bloodstream, and that can be bad, particularly if the drug does bad.
Oh yeah. It's you can't take just because you can ingest it doesn't mean suppositories are. Yeah. That's a whole other thing. Yep.
Okay, so
I don't know what you just said, but okay.
12th Amendment defines how the vice president and president are chosen by the Electoral College. It basically says essentially that making two positions, competitive rather than the first. Where it was before the 12th Amendment, the first person in the Electoral College became president. Second person became vice president.
Right.
So you can imagine when you devolve into a two-party system, that one party gets its president, the other party gets its vice president, and they thought that would be hazardous to the president's health. Seriously, that was one of
yeah. Well, because now it's there's a huge incentive to assassinate the president from the party has a huge incentive. The losing party has a huge incentive to assassinate the president because if they kill him, they become the winning party.
Yeah. Ironically, we actually had a vice president that committed murder.
Really?
Johnson?
Burr, isn't it?
Oh yeah, Burr.
What?
And Johnson. Well, Burr shot Hamilton, but I don't know if that was murder.
I thought you meant like of the president.
There's also
president.
Yeah, I mean, well,
that's never happened.
I'm going to argue LBJ, but we can move forward. That's a whole other. That got Landon's attention.
I mean,
it makes sense outside of the assassination risk to have if both parties are going to be so opposed and they're, opposed on ideologies on how the country should be run, it would make sense that at least every year you're going to have a high-ranking representative from both sides making decisions together, and that you might have a more cohesive government that way.
Yeah, except the Constitution doesn't say the president and vice president have to agree.
Right.
Constitution basically says the vice president can preside over the Senate and break ties, but otherwise sits around waiting for the president to die.
Yeah.
And doing nothing other than
he's got one power, and that's to assume the president, or no, two powers. He's got the 25th and breaking ties. Yep, that's it.
Yeah,
that's all
he can the process of becoming, if he can become president, if the president can't be president anymore, and he can break a tie in the Senate.
Can he be a member of like Congress or Senate if they've been vice president, or is that just the presidency that blocks them from that?
Well, he can't be a member of Congress because members of Congress can't hold other offices.
No, I mean after the term is done.
Oh yeah, after you're done,
so,
right? If you're
so
done.
the rule of the presidency is once you've been president, you can't hold any other office in the House.
Taft,
oh yeah, you can. You just can't hold them simultaneously. But yes, you can. Yeah.
So Taft was a legislator,
okay,
a member of Congress. He was a president. He was also on the Supreme Court. He's kind of an all-around, pretty big guy, literally speaking. All right, so 12th Amendment talks about that. 13th Amendment abolished slavery throughout the United States. 14th Amendment assures that all citizens enjoy not only the rights of the federal level, but also the state level. Right? It removed that 3/5 slave thing and ensured the United States would also, it ensured that the United States would not have to pay the debts of the rebellious states. It also had several measures designed to ensure loyalty to the legislature who participated in the Confederate side of the Civil War. So people who fought in the Civil War could no longer hold office.
Oh wow.
So that's the 14th Amendment has that equal protection clause. That's also a big amendment that comes up in many court cases. 15th Amendment ensures that race cannot be used for criteria of voting. So you can't say, you're this race, you can't vote, right? 16th Amendment assures that the United States can collect income tax without regard to the population of the states. So you could have a tax based upon your income, right? That was the 16th Amendment, the income tax thing.
So I think the 14th Amendment is citizenship for slaves, right?
Yes, and it basically says that all citizens of the states have rights.
Right. Okay.
They're equally, but if you have debt over the Confederate stuff, too bad. And if you were a Confederate treasoner, you can't hold office.
Because I remember there being a little memory trick in school for those amendments of 13, 14, 15 free citizens vote.
Yes, absolutely. and that by the way, the 13, 14, 15 amendments were required for the states to so-called readmit, right? They said, okay, because you did this thing, you have to go and reapply for admission, which is kind of an interesting issue because some people use that as saying, well, if they had to reapply, that means they successfully left. So I tell you, this debate continues on and will continue on for a long time. Right? But 13, 14, 15 Amendment, the Confederate States had to ratify them because what happened was that the Union States, when the Confederate States weren't around and were participating, passed 13, 14, 15 Amendment, that they made the Confederate States have to ratify them before they came back in full terms, right? 16th Amendment again was income tax, right? You collect tax without regards to the population, right? So 17th Amendment shifted senators choosing senators from state legislatures to people, right? So prior to the 17th Amendment, senators were selected by each state legislature. If you weren't in the state legislature, if you're just common citizen, you couldn't elect your senator. 17th Amendment says people do it. 8th Amendment established it abolished the sale and manufacture of alcohol in the United States. The so-called Prohibition Amendment. By the way, that was an amendment that got pushed through, associated with the suffragette movement, which was largely a women-led movement.
Passed, of course, passed with 2/3 voting, 2/3 of the states ratifying it, despite the amendment that comes next.
Or 3/5, right?
3/5.
19th Amendment asserted that gender can't be used for criteria for voting. So the 9th Amendment guaranteed women to vote. And by the way, the 9th Amendment is going to be coming up in things relating to other gender-related issues. 20th Amendment starts new dates for terms of Congress and president, clarifies how the death of what would happen if the president died before swearing in. So if you elect a president, but they die, what happens? 21st Amendment repealed the 18th Amendment. So that so-called prohibition was repealed. Interesting enough, it is still quite difficult in some cases to buy wine from other states if you live in certain states. 22nd Amendment sets a limit on the number of times a president can be elected to 2 terms. It has exception for a vice president who assumes the presidency after the death, and establishing a maximum term of any president. Basically, maximum that someone could be president is 10 years. So if you are vice president and the president dies in the second half of their term, that 2 years doesn't count. You can then be elected twice. So that's why you can be federally get president for maximum of 10 years.
Wow.
23rd Amendment said that the District of Columbia has 3 electors in the Electoral College. Before the 23rd Amendment, people in the D.C. couldn't vote for an elector. Had no say in who chose who could become president. Now, it doesn't make D.C. a state. It doesn't give them representation in Congress, but it grants them the ability to get electors. They have 3 electors that they can do. 24th Amendment established that no tax could be charged to vote for any federal office. So there was a thing called poll taxes. One of the things that the largely Confederate states did was to say, okay, you forced us to ratify the 24th Amendment. You gave these people you said we couldn't prohibit black people from voting, but we'll charge black people $1,000, and we'll have the option of our polling people waive the fees in case of great need. So how do they do it? Well, actually show up. They'd say, "Give us $1,000, you can vote." I don't have $1,000. Sorry, that's the tax. Right? Oh, yeah, vote tax. So yeah, come in. You've been having a hard time here. Your husband recently died. We'll let you go without. We'll waive your thing. That was what's happening. And so the 24th Amendment says you could not tax someone. You cannot charge someone for voting. It's one of the reasons why, if you have a mail-in ballot, you do not have to put a stamp on it.
Oh. There's also something that requires companies to let you vote.
Yeah, those are state laws.
Okay.
So 25th Amendment further clarifies a line of succession, and it establishes rules for a president who becomes unable to perform their duties. President Wilson essentially became infirmed, incapable of communicating, kind of speech, and President Wilson's wife and the chief of staff essentially would go into the room where he was an invalid and come back out and say, the president just signed this and says this, right? In fact, people can show that she routinely forged his signature and basically ran the office So
First female president. There was a really good drunk history about that.
yeah, and so, but the problem was it was just that they were just being nefarious. But there was no way to have someone who hadn't died but was incapable of remaining president from getting rid of them.
I see.
And no one would murder them. So this line of succession, it talks about the cabinet. And so there's been a whole bunch of things about some recent presidents, whether they're fit to hold office. And there is a process by which the cabinet officers, there's a debate on what's the cabinet officer, could, along with the vice president, say the president's capable of performing their duties, or the president could give up saying, hey, I'm going to go on operation, so suspend me, so forth. So 25th Amendment is worth reading. 26th Amendment says any person 18 years of age or more can vote. So it forced a uniform voting age across the nation of 18. And finally, the 27th Amendment assures that any law that increased the pay for legislators cannot come to effect until after an election. Now, that was a law, that was an amendment that was proposed way, way, way back in the 1780, I think it was back in like 1789 or 1790, way back in that line, back in the original set. And what it said was Congress can't vote to up their own salary. There has to be an election before that increase in salary has to go into effect. And that languished for all that time until some archivist said, hey, there's this amendment. It's one vote short of being ratified. And so that state ratified it. And guess what? It became our newest amendment. But 3/5 of the state.
All right. Well, we are coming up on 90 minutes, so I was curious as to what else. So was this
that's the Constitution. That's the amendments. That's everything that's in it.
It's not as intimidating as it sounds in terms of like what's in it and the length of it.
So, all right. So I'm okay staying for a little while longer. I don't know if Courtney is going to need to bail at some point, but we can play it by ear for a bit and see how it goes. What was there was an interesting one.
So what do you think?
What I find interesting is just that it's very hard to get an amendment passed, and they passed an amendment to ban alcohol. And then I want to say it was 2 years later. I forget how long between the 19th and the 21st, but they banned an amendment. They have an amendment to ban alcohol. It requires 3/5 to vote for it, and then 2 years later, roughly the same number of people vote against it. It was just
yeah. And by the way, there were movements. So we said that the 18th Amendment was a prohibition amendment, and the 21st repealed it. There was movements to repeal the 21st Amendment and restate the 18th Amendment. Right? That's not.
So then I have a question about the 14th Amendment. There are a number of people who call the 14th Amendment essentially an ERA, and that it actually should be should be sufficient to cover any future ERA issues. So that
what's an ERA?
Equal Rights Amendment, that it says if read correctly, quote, it empowers women, it empowers blacks, and that you should need no further amendments to ensure that citizens are treated equally. That in fact the 14th covers that. What are your thoughts on that?
Well, there's always this thing about, does it explicitly state or is it implied? Some ways you say, well, what does the Constitution actually mean? And one cynical answer is whatever the Supreme Court says it means.
Right. Yeah.
So then you come into areas where you sit there and say, hey, we think that women should be able to serve in the armed forces. I say, okay, And then say, well, therefore, if you have a draft, you have to draft women and men.
Mm-hmm.
Well, blah 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 blah. You say, well, hey, wait a minute. If the rights are applied to everyone, why not? Well, there's debate. Well, some people say if there was an amendment that says you can't discriminate based upon gender, then the Supreme Court might look at a law that says men have to do this, but women don't, or vice versa, would be considered unconstitutional. What do you think? I mean, what's your opinion on that?
Sorry, I had to
My
deal
opinion?
with a message, so I'll let Courtney. I mean, I will let Courtney. I have a very strong opinion on it, but I think we should hear from Courtney.
I mean, I feel like in terms of a draft, I think that isn't a good thing in general. I don't think you should be forcing men or women to go to war, but allowing people of all genders in to sign up voluntarily, I think is fine. So people talk about that of like, if the feminists really want equal rights for women, then women should be in the draft. And I was like, I don't think anybody should be in the draft. But I do think there have been countries that have a mandatory service after high school for students. After students graduate high school, you have to either join the military for 1 year or do some sort of civil service for 1 year. So like volunteering full time for something, and it's for the government in some official capacity outside of becoming a soldier. So it's almost like, most people join the military, and then you do have a lot of people who are in service to their government in other ways, in more peaceful ways. So I think that would make sense, where you would have every person has to serve their government for 1 year after high school in some capacity.
Sure.
Or something like that. So I do, I like that idea, but I don't know if everybody would feel like that blocks them from, like professional athletes of the time of their prime to become, professional athletes, or so there's some exceptions to that, but it does seem like joining the military should be something that's voluntary across the board. I don't think anybody would from a human level support that. I don't know. I guess
it's more than just there. It says, does if you establish a law saying men get paid this and women get paid that,
right,
is that unconstitutional?
I think so.
I don't think it's right, but is it constitutional? Now let me read you a clause of the 14th Amendment as it's written, as it was written, to let you know why some people think that the Equal Rights Amendment was needed. Why the amendment?
Oh,
saying
you mean
based on
outside
race,
of the amendments?
And why? I mean, I talk about the actual 14th Amendment when it was ratified. This is what I read you this clause, and this is why people needed to have the 18 voting age. You can't discriminate based on race stuff. Why you can't discriminate based upon sex for voting. It said, representatives shall be appointed amongst the states according to their respective numbers, counting the whole number of persons in each state, excluding Indians who are not taxed. When the right to vote in each state for choice of electors for president, vice president, representative of Congress, the executive and judicial officers of that state or members of the legislature thereof is denied to any male inhabitants of each state, being 21 years of age, citizens of the United States, or any way abridged except for participation in rebellion or other crime on the basis of representation, therein shall be reduced in proportion which the state number of male citizens shall bear the number whole male citizens of a 21 years age of each state. So basically it says...
I thought it said citizens. I didn't realize it said male. Yeah, okay, I didn't realize it said...
And men men count, and people like Indians don't really count, and unless they're taxed, and other sorts of things. That if you heard that clause as it was written at that time, and you are a Supreme Court justice trying to interpret the Constitution, now the thing about Indians was a way to say, well, yes, who's an Indian, what it is, and that's where they could go and say, well, basically saying people not white was how they excluded those people out. And then, of course, people who were under 21 were excluded. And then people who were not male were excluded. And by the way, this was an argument made to deny gay people the right to vote. Because it said, well,
here's a look at this day in history.
And so forth. There were other things there. So this is why
Peru became independent
some people, if you heard that clause, could say women don't count and certain races don't count and certain people that are not old enough don't count.
Well, so here's I pulled it up, and unfortunately now I got.
I'm not advocating that. By the way, I'm not advocating that. I'm saying that's
okay, so Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. So you've established that men, blacks, minorities, they're all citizens. So right off the bat, and I forget what was the other one where all citizens need to be treated equally. But then
enforcing law, privilege, blah, 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 yes. But yes, but all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and reside. So this means that if you are born in the United States,
yes,
the Constitution guarantees you citizenship. It does not mean that the executive can say you get kicked out, right? So you can imagine a family comes to the United States, let's say on a visitor's visa, or sneaks in, doesn't matter, and someone is born in the United States, that person becomes a U.S. citizen. You then go and say, hey, these people should be in it. They've overstayed their visa. They snuck in, whatever the thing is. Kick them out. They say, yeah, but this kid's an American citizen. That person has a right to due process. That process has equal protection, blah, 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 blah.
So the only reason, so if you take that in conjunction with, nor shall any state deprive any person of life, liberty, without, and then the Equal Protection Clause, nor deny any person within its jurisdiction equal protection of the laws. So the way I would read that must necessarily include any minority, so long as they were born in the United States or naturalized.
And I agree with you. I agree with you, Nick.
Yeah.
But you have idiots like Clarence Thomas.
Oh, God.
Probably one of the person who is the least qualified member of the Supreme Court in the history of the United States, amongst the least qualified. It's one of the things that Bush Sr., his shame is that idiot nominated him. I don't know, Congress let him in. That person, along with his friend Scalia, who is dead, thankfully, would go through. Yeah, it's one of the best things that Scalia did.
Oh my God, was I?
Oh.
So where I'm going with this is that he goes and says yes, but he'll go and read something like the Second Amendment and say, well, so that kind of means that if you are gay, your marriage doesn't count because it doesn't say it here. It's equal protection, but the equality includes not being allowed to marry. Right? There's a reason why Thomas doesn't say much, because he realizes that oftentimes he sounds like an idiot. So he prefers not to say something and instead have his clerks write his stuff for him.
Huh.
So,
Nick, I'm not joking.
I know I have pretty good experience, and a lot of judges do that anyway. Just for He does it because he doesn't want to sound like an idiot. Most of them do it because they have too much paperwork, and that's not what the.
But but people like him would read these sections and then interpret it the way he wants to, right? So one of the things that Scalia was really bad at doing, he had an agenda. He had a religious agenda. He had a moral agenda, and he would read the Constitution, trying to cherry pick to justify and rationalize his agenda. Now, Scalia was very good at writing arguments that sound cogent and coherent, and then Thomas would often concur. Right?
Interesting.
But this is good. See, this example, and what you heard Nick and I say is I gave you two ways you could spin this amendment to say, well, if it says a second clause that it's only males, then that equal protection really is equal protection of citizens. Let's say a person really is a male, not just necessarily female. And so while they can vote, Second Amendment, wave your hands, and you can try to rationalize, right?
Yeah. Well, and I think that's the most important thing, is that you were saying that in order for certain protections to actually be guaranteed, you kind of have to explicitly state them so that the interpretation can't be as as much played with, because there's people. It's insane. If you watch C-SPAN, it's like
Now the Ninth Amendment,
people will jump through crazy hoops.
And Courtney, you're right, because the Ninth Amendment says very simple: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Right. So it says, Ninth Amendment says, it doesn't say in the Constitution that women should be treated fairly. But Ninth Amendment says just because it doesn't say that doesn't mean they don't have that right.
Right. Okay.
To be treated fairly, right?
Okay.
So, but again, you can get somebody who is pushing an agenda in the Supreme Court who sits there and says, well, they call them literalists, right? That they say, I am a absolutist, and we want to literally interpret the words of the holy sounding fathers, inspired by God to produce this Christian-like nation, thing, and I'm not kidding. Nick, am I kidding?
No, you're not. In fact, I want to get into schools of interpretation in a few minutes, because there's the literalists, there's the original interpret.
So, I get it.
So did you see
crazy.
how stuff comes in? So that's why someone might say an equal rights amendment that basically nails and says that gender does not constitute a reason of denying rights would be needed. Even then, the Supreme Court can interpret things in a way that can be some of the hoops that the Congress has gone through to rationalize their decisions would make even Trump say, huh?
So another really interesting question. Quote, does Landon ever sit in his refrigerator and dream of Antarctica?
No.
Oh, here it comes. Here it comes. I shouldn't have. He's going to have Arctic ice. He has ice from Antarctica. Courtney, I am betting you $30 he's got ice from Antarctica. He goes there. He hangs out. That's his. When he's not in a volcano, he's.
There it is. And this came from the core. I actually cored at the South Pole, and this is full of ice core.
I told you, Courtney. Did I not tell you? Did I not?
I know.
Tell you?
This is crazy.
So it stays in my freezer.
That is cool.
Now I must say that it's never been as warm. That ice has never been as warm since because it came over. I packed it in dry ice, kept it frozen, and it's actually not a lot warmer in my freezer than it was back at the pole. But anyway, but back to say, so do you see how, in some ways, what is constitutional? Some of it comes from the fact of, well, what does the Supreme Court say, and what does the Supreme Court enforce? And then what does Congress and the president do anyway?
Right. Yeah.
That's one cynical way of saying what
Yeah.
does the Constitution do? It's what people say it is. But the
Well, but
Constitution,
I don't think it's
go ahead.
quite cynical because I don't think it's quite cynical because that's kind of the job of the Supreme Court, right? It's to settle these things according to what the Constitution says of what they think, and there's a reason that we try to keep it balanced between the parties. But it's also they are the ones that have the expertise to make that kind of call. And one would wish that because they are there for life that they would be set apart from public opinion and set apart
Yeah.
from being partisan and
Yes.
agendas, but they're not. So that's annoying. But ideally, that's what their role is supposed to be, is
Sure.
to be the interpreters of that and to be the ones that can spend all day figuring this out, because the rest of us don't have time for that, right?
Yeah.
So
But
it's interesting. Yeah.
but here's how, if you can pass a law on anything, even stuff that's blatantly unconstitutional, if the but it's the courts that come and say, hey, that's not constitutional. For example, let's take something very, very, and again, understand the Constitution has very, very simple statements. It doesn't sit there. Constitution doesn't sit there and say, okay, for purposes of this law, yellow cars are like this. They have to have 4 wheels. The tires have to be this pressure. It doesn't go into this. It's high level stuff. So let's look at the 19th Amendment, the Suffragette Amendment. Simply says the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. Let me put that again. The right of the citizens of the United States to vote shall not be denied, you can't do it, or abridged, only later, by the United States or any state on account of sex.
Okay.
So that to say, well, then that allowed women to vote. That took that ambiguity that some people found in the 14th Amendment and said, no, you can't deny it on account of sex.
Okay.
Well, and here's another one that I like, just because it's so simple and yet nobody can agree on. Nobody can agree on the meaning of basically any of the following words. So a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
I knew it was going to be about this.
Yeah.
But
so what's a person? I mean, they can't even, when this was written, a person was any 11-year-old child, white male, 10 or 12 actually, 10 or 12 years old or older, white male, that's it. No women, no blacks. And I mean, at 10, that's a person when this was written. It's not a person today.
So let's see. Let's focus on the 19th Amendment because it's a little bit less controversial. But let me show you an example again of how someone reading this thing might interpret it. They say, okay, it says on account of sex. All right. So therefore, the Constitution establishes sex. And these people that claim to be gender fluid, non-binary, we can discriminate them because it recognizes sex,
right?
Which they and you say at the time was women wanting to be included,
right?
So they can make this torturous argument to say the 9th Amendment therefore does not recognize transgender, gender fluid, down the line, and therefore we can discriminate on them because it only is on basis of sex, which they say is male and female. I understand. I'm not making this thing, but that there are people and understand that there's cases before the Supreme Court now regarding is it legal to discriminate against people who are gender fluid, transgender, so forth, and these arguments that I just gave you are going to be some of the things that are being argued by current justices now.
Yeah.
And you say, but how it's clear? Well, if you're a lawyer.
Well, the reason I picked the Second Amendment isn't because it's controversial, but because it has the use of the word person, which we still don't know what that means. I mean, we don't actually know what constitutes a person. We don't know what a right is. We think we do, but like rights in theory can't be infringed on, but we do infringe on rights for certain reasons, you know, is having to buy. I mean, honestly, the way I read the Second Amendment, even having to pay money to buy a gun is an infringement for the Second Amendment to be truly
Yep.
what it. I would say they have to
Right.
give away guns for free, and there are countries that do that. There are countries that force you to take a gun, actually. But you know, so
Switzerland.
Switzerland, yeah, exactly. So that's my that's why I love the
Yeah.
Second Amendment, is because I'm sitting there going, nobody knows what a right is, what infringement is, nobody knows what a person is, nobody knows what any of those words mean. It's up to so much interpretation. We all think it's obvious. None of us agree.
Yeah.
And so what happens if someone comes up and says, here's a law, and we want to prevent women from being able to become corporate officers or corporation. We pass a law, and you go through the legislative process, and the chief executive signs it. It's a law. You say, well, you got to pay the law. Well, someone comes and says to the court, hey, we think this is unconstitutional. This violates the 14th Amendment, violates the equal protection law and other things of that nature, and it violates the spirit of the 19th Amendment and on down the line. And so what happens is a judge will look at this and say, yeah, it's pretty clear. This violates the Equal Protection Clause of the Constitution. And so the judge says I find this law to be unconstitutional, and therefore the person who is suing to say I don't have, that's wrong, wins. They also establish a precedent, because let's say you're a district court judge, and you say, okay, yes, you cannot prevent this law keeping women from becoming corporate officers is unconstitutional, and this person's suit wins. And by the way, we established a precedent that anyone who comes to this district and sues on this law automatically wins. Well, you got some other place that says, yeah, but we don't like women because they're religious and they don't like women. And so they uphold it. They say, well, wait a minute. This court says you can. This court says you can't, right? And so it appeals to, let's say, the Ninth Circuit Court, which comes and says, come on, folks. This is ridiculous. The Constitution clearly says you cannot prohibit women from becoming corporate officers. So we uphold this court and deny that court. Okay, you think they're pretty good, but then someone goes and appeals and says, I want the entire Ninth Circuit, not just some justice or three justices to do it. And so Heinz Court comes back and says, yes, of course, you can't do this. Well, someone in the first district goes and it turns the other way. Or let's say the president decides he doesn't like that. So he goes and says, I'm not going to not enforce it. I'm going to aggressively enforce this. I don't recognize this court. So the Supreme Court gets in the way, and they decide to hear it. That's a big if. And then they hear all these things, their arguments, they come back, and you have some people who will ideologically say yes, some people ideologically say no, and the people in the middle kind of come up with the stuff in the middle. But at some point, if the Supreme Court says that law is unconstitutional, it stays on the books. It's just that anyone who goes to a court and sues automatically wins. So Congress says, that was a pretty dumb thing for us to do, and no point in having a law in the books that everyone automatically wins over. So we'll go and repeal it. That's a case. So Congress makes the laws, writes the laws. The president signs the bill, but the courts can say that's not constitutional. And by default, if you come to us for courts for complaint, for redress of grievance, something like that, or we'll find you in favor, right? So this is why when comes forward in some of these very important cases, can someone's religious rights under the First Amendment say that they can deny women rights under the 14th Amendment
Mm.
to certain healthcare,
Mm-hmm.
right? If this group of nuns, and there's a case before the Supreme Court right now where the nun says our right to practice freedom is being offended by our requirements to be
Yeah.
part of a corporation that has to give healthcare benefits.
Mm-hmm.
What's going to happen? You tell me. This is why justice in the Supreme Court matter.
Yeah.
This is why the person who is president and the majority of the Senate matter. As one of the reasons why, right? Not only why, but one of the reasons why. Any other comments on there, Nick? On
I have
Well,
no
I think
Okay, yeah.
I'm turning into a pumpkin. I'm tired, but very, very important things. I don't want to discount that.
All right. Well, Courtney, thank you very much for joining us,
You're
and
welcome.
look forward to seeing you soon. Yeah, I know. Oh God, I think we got maybe about 20
I'm
minutes
just
left. I
gonna
have one other
yeah,
sort of
yeah,
overarching topic
yeah.
I'd like to hit,
go to
but
bed.
all right. Well, sleep well.
This is
Good to see you.
This is where I live. All
Bye.
right.
Thank you,
Well,
Courtney.
lovely listening and lovely learning. I'm gonna watch it back so I can hear most of it.
All right. Thanks.
All right, thanks.
So,
So, Nick, as you were saying.
okay. So, what I'd like,
nice input.
what I'd like to, let me just make sure I get that.
So we're talking about I think you wanted to talk about the styles of interpretation of the Constitution.
Yeah. So let me just quickly. I gotta take care of one thing here.
Again, for those that hear me arguing over certain things, many times I'm bringing up stuff not because I believe them, but because I'm parroting you a particular line of argument, right? I'm trying to give you notions that how people read simple text can become quite convoluted sometimes.
So you heard it here first, folks. He may be wearing a very nice turtleneck, but in the end, he is a parrot. So what I wanted to ask is, there are many schools of thought when it comes to, and basically everybody applies it different. I mean, there's a million ways to interpret it, but a lot of the interpretations have been broken down into schools of thought as to how it should be interpreted. We've actually sort of roughly touched on a couple, but I was wondering if we could go over what some of those schools of thought are: originalism, textualism, strict constructionism, stuff like that.
Yeah. So originalism sort of says that the original intent of the Constitution is supreme. And you need to understand the framers of the Constitution, what they had in mind. And they will go through and look at the debate going on over the ratification. Look at read the Federalist Papers, and if they can find an interpretation saying, well, this is what the framers meant, even though they didn't say it exactly, then that's what the Constitution should be.
So what do you think are some? Yeah. So I want to go over each of these, and also what your views are on them. What are some pitfalls? Do they work? Do they not work, and why?
I don't care what the so-called framers of the Constitution thought. I really don't give a rat's ass what they think. I care what is relevant today. Now, that comes at a peril, because how do you know it's relevant today? Well, because it's fluid. But if you had the original framers of the Constitution in mind, blacks would still be 3/5 of the person. Women wouldn't be right, owning rich, while white male property owners would be able to vote, and no other horrid things, right? That was the Constitution they had in that day. And so I'm not interested in that opinion. In fact, I reject a bunch of stuff in that opinion. But the Constitution was written in a way to be mutable, right? There's an amendment process, and there's a judicial interpretation process that allows someone to say, even the Supreme Court can change its mind. Plessy versus Ferguson versus the famous case, that Thurgood is the one that Thurgood Marshall, before he became justice, argued, Why is everyone drawing a blank? I'll come back to it. But anyway, the point is that
Brown versus
that
that was
Brown versus Board of Education.
okay.
Right? Yes. And so we've seen even the courts change its mind slowly over time. But down that road to that extreme lies a really dangerous thing, which is Constitution says whatever I say at the time I say it, right? You have to have some basis of doing that. So a better way is to say, well, if you have nothing else to go on, look at the intent of the framers of the Constitution. But that's the last thing you should look at. If you don't have good Supreme Court rulings, if you don't have modern interpretation, then that's the thing you fall back on last. What do you think, Nick?
No, I mean I agree. I don't think there is any one method. I think strict, strict context, strict constructionism, or which suggests that it's actually only past precedent that you go on. And then barring that, you can make new precedent. The problem is, I go by the living document theory, which is it's constantly supposed to be being changed. The founders could not have imagined what an internet was. They couldn't have imagined a tactical nuclear weapon. They couldn't have imagined all of these things, and their intents probably were great for what they were doing at the time, and I'm willing to accept, I don't know that I agree, but I'm willing to accept the argument that they were all geniuses and that they, this was the masterwork of world literature, for lack of a better term. Things have still changed, and they're still human beings. They still make mistakes. They still had compromises. The 3/5 compromise. They still it's still a political document, and since the politics have changed, I don't think you can look exclusively at their intent.
Yes, and I think as well, one of the things that you must consider is that even the framers of the Constitution put into the document a way to amend it, and that the courts can interpret it. That was also part of what was happening, is that the Constitution says that the Supreme Court is the highest court of the land and can basically interpret the Constitution. It's one of the checks and balances that the courts can prevent a Congress and a president from running roughshod over the Constitution. Supreme Court's one of the things that says, no, you can't do that sort of thing. That's one of its important says. Now, one of the problems with I find with so-called, they talk about strict constructionists, right? And Scalia would say, oh, I'm a strict constructionist. I don't go and try to read into the 19th Amendment on account of sex and create all the crazy sort of things. I read what it says. The problem is that the man did that as long as it suited him. When it did not suit his religious agenda, his moral agenda, he would go through all kinds of readings, interpretations. For example, Bush v. Gore, when he stopped the Supreme Court of Florida from processing an election dispute in Florida, not only did he author that to say, here's a case where the federal government stepped in to change the result of a state vote, but he then had the audacity to say, and by the way, this is not established precedent. The Supreme Court will only have this precedent for this one law in one case only, and it cannot be used as precedent later on.
Just
what a schmuck.
Just to clear that up.
Schmuck.
Just to clear that up for the audience, because I think that's a very important. I mean, basically, for all intents and purposes, any court decision is considered a set precedent of some kind going forward.
Yeah.
And I mean, that's just sort of de facto. That's how it works. And this decision was highly controversial. There was basically no precedent for doing it, and they knew that, which is why they said, okay, this is such a bad decision. It can't be used as precedent for any decision ever to be made in the future of this country going forward. It's a one-off. We are making this as a one-off. Nobody's to ever refer to
Literally,
it.
they said that.
Yep.
So, yeah. So these people that say strict constructionists, I say it's only when it matters. When the construction doesn't go their way, often strict constructionists become very, very, very relative of Citizens United. Citizens United basically gave corporations rights to extraordinary rights, including ability to contribute money. So Congress passed laws saying limiting on the amount of money that could go and prohibiting corporations and unions and other things from donating. And so, and Citizens United case came back and said, yeah, you cannot effectively, a little bit of hyperbole, citizens are people. People have the rights to freedom of speech, and therefore corporations have the right to freedom of speech. And freedom of speech includes the right. Speech includes bribing and they're called actually donating to a political campaign. So it said, you know, they said, well, if we said they passed a law saying you can only contribute to money to campaigns of candidates we like, that's unfair. Well, now if it says, well, corporations can't contribute, only people can. The Supreme Court says, the United says, no. Corporations have the right to do that. So corporations and PACs and unions and so forth, they can flood candidates with all kinds of money, and you can't do it. The only way that you could, so there are ways you can get around that, but you'd have to get Congress and the president to do so, and that's currently difficult. But that's another case of constructionists where effectively, if you want to know why is politics so bad,
Mm-hmm.
because many ways the politicians we have, many of them are the politicians that the best politicians that money can buy. That not always, but money buys influence, buys power, buys amendments to bills. So when something like this $1 trillion aid package, $2 trillion aid package on the pandemic was going through, all kinds of corporations spent money getting members of Congress to put in all kinds of little interesting riders to allow this and that to happen, even if it's not even related to the pandemic. And they can do that. And then they can turn around and a corporation can turn around and say, unless you let that amendment, which allows this company, I mean, you have laws that basically says a company that does online retail who's headquartered in Seattle can decide to pay their workers less than minimum wage under certain conditions. Everyone knows that's Amazon. And someone says, well, you can't do that. That's fine. And so the particular lobbying group for online realtors goes to a senator and says, if you don't vote to allow that amendment to go through, we're going to spend money on your opponent's campaign. Well, Supreme Court says corporations are people, and giving money to a politician is speech. So unless you're able to overturn the Citizens United situation, case, you get the best Congress money can buy, unfortunately.
So let me ask you this parting question. If you could change one thing, not necessarily about the Constitution, but about the American political system as it is, that you would think would have the most efficacy in changing our system for the better, what would it be?
Limiting the ability of campaigns to raise and spend money. The cycle of, and by the way, when I was elected official, I would routinely refer to campaign contributions as legal bribes. Drove the city attorney nuts. Not do that. But
I'll bet you did. Which you're a pain in the ass, which is why you very much belong on this show. But please continue.
So, but thank you. And so the cycle of money to legislation to and mostly, what does that money do? What happens when you donate money to a campaign? It doesn't stop at the campaign. The campaign spends it, and they spend it on what? On media, on advertising, not only paper flyers, but on TV and radio ads. It is the media that benefits from campaigns. It's why we have 2-year plus presidential campaigns, because the media knows all this money, billions of dollars of money, is going to be spent on campaign, given to campaigns, try to influence them to turn around and do what? To buy airtime to try to push out these ads. The media is not going to sit there and say, yeah, it's a good idea to stop all this money going to campaigns, because they cut their own throats.
Yeah.
So that would be the thing, is to limit the ability of a campaign to spend money. I mean, I would like to, for example, ban it would be impractical. It would be nice if we would ban all political ads on TV. So they couldn't spend money. The campaign couldn't spend money on TV advertisements. Now, some countries, what they do, that's not a good idea, because some countries, what they do is the government sits there and says, well, you can't do campaigning outside of an election. So the government does these press conferences where they show, look at what we're doing, all the great stuff. And it's not a campaign. We're just informing the voters, right?
Yeah, there's so many ways around it.
It's not clear cut, but the ability of money, not just corporate and so forth, but the ability of money to go into campaigns. And here's what happens when you're in office, is that there'll be some writer where you sit there and say, well, this is obviously they're trying to allow this particular tech company this special little perk. And someone sits there and says, why does a politician who's in a safe seat raise tons of money? Why was Newt Gingrich became Speaker of the House of Representatives? Because he was somehow this magnanimous person everyone liked? No, because Newt Gingrich was able to raise a ton of money. He was in a seat that was virtually guaranteed his re-election, and he could raise a ton of money. Now, what does he do with all that money? Well, he does this. He goes to you and say, Nick, I need your vote. I know that you come from a state that likes oranges, but we need this vote to make it harder to sell domestic oranges. So I can't do it because my constituents love oranges and we depend upon orange being sold. Well, Nick, you're going to come up for a re-election in 2 years from now because you just got elected. I can put $500,000. I can donate $1 million to an opponent. Now they may not win, but I can cause you to have to fight for your just your primary alone. Or I could decide, if you just somehow, I'll tell you what, Nick, you abstain on this bill unless it's about ready to go down to defeat, and then you have to vote yes. And if you do that, I'll make sure this particular group gives your campaign $100,000. Will you do it?
I think that's an interesting point. Well, here's now I have a counter.
Okay.
So somebody came up with, and I like this. Trevor Lund said, have an independent electoral commission draw up and manage district boundaries, which I think is a good, because I think one problem is we're having Citizens United gets to pass because of gerrymandering. I think we had covered this. I don't know if that was last time with you or not, but the gerrymandering allows the election of governors. Governors are allowed to, actually it went the other way around. The part of Rove's plan for the permanent Republican majority was to elect governors, have the governors help redraw the districts so that you could get this sort of permanent election process of Republicans going into Congress, and then get approve only judges that fit whatever it is that you're trying to accomplish. But
Yeah.
one of the things, so I think I really like that one. But the one that I think
Yes.
I'm close to
I
you
do
on
too.
this. Mine has been make the money completely not transparent, sorry, opaque. So if you wish to donate to any campaign, you can. As a business, you can. As I don't think businesses should, but working within the framework that we've got now, okay, because of Citizens United, if businesses want to, fine. I don't think they should, but just with what we've got now, the one thing I'd change is all money for all political campaigns, any donation, would have to go to um, a independent government agency. That agency would then distribute that money directly to the campaign monthly. The campaign would not know who it got the money from, and it would be illegal to divulge that information. It would be illegal for you to say, "Hey, Nick, I'll give $10,000 to your opponent if you don't." You're not allowed to divulge that information that you're going to, and people can't say, "Hey, I'm the one who donated $10,000 to your campaign last year." And even the people who do that, if you're a politician, you never know precisely who's telling the truth and who's lying, because there's no way for you to trace where the money's coming from. So
that's because it's interesting. We have to say what it is. Well, what happens is that group of people gets together and donates it to the Society for the Betterment of the Environment, and Society for the Betterment Environment then goes and gives you your $100,000. And
yeah,
so
but
you say, "Well, I just had $100,000 from the Society for the Betterment of the Environment. I'm an environmentalist." No, you took a bribe from the Speaker of the House to vote against your constituencies to screw your orange growers. So you wouldn't have to spend all this money to get reelected. That's what happened. But you orchestrated such that the group's name looks like the organization which is pure as a driven snow and would never do anything mean to anyone. Right? Comes into play. I had on a council an ethics rule I proposed, which stated that a council member had to state prior to casting their vote all of their interests in the vote. So if you were voting on a for or against a particular property development, you had to sit there and say, "For the record, I received $100 from the Vidovich Development Company, and I received $80 from the trade union workers, and I received blah, 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 and therefore I cast a vote for yes," right? You had to declare that. The reason why that didn't pass was they said that would make the meetings too long. I kid you not.
Oh, I believe you. I have no doubt you're telling the truth.
and so the problem with just opening and declaring it is that you can money launder stuff around, right? You can have a Russian oligarch donating money to a United Arab Emirates group, which donates money to a particular international travel organization headquartered in the United States, which then donates money to a political action group, which donates money to the Friends of Warm Puppies. And therefore you say, "Well, I'm not being influenced by foreign people. I got all this money from the group that likes warm puppies because I like warm puppies. Don't you like warm puppies?" Right? So the way that you could, but why do people have to raise a lot of money? Because the media charges lots of money for these ads to go on. Remember, all this money that goes into campaigns doesn't end in a campaign. It ends up in the media. It ends up in the radio, the TV, the newspaper, the printer, so forth. The media group only receives, and by the way, they don't care whether you're Republican, Democrat, liberal, conservative, middle road. They want the money. And they like when things become controversial. So they'll go, if they see in a race looks like they're lopsided, the media will accentuate the other side, say, well, it's lopsided, but this person might actually win anyway, right? Because they want all this money pouring in. There are people fighting money-wise to try to get money into the campaigns because they ultimately receive it. So so I would do this. I would have a constitutional amendment saying Congress shall have the power to regulate the time and funding of campaigns in all states. And Congress will have the power to pass legislation to enforce this amendment. Pure and simple, right? It would eviscerate Citizens United and give the ability to say you can legislate. Because you could sit there and say, presidential campaign can only last 6 weeks or 8 weeks or something, right? You could limit the amount of time. That's one of the ways to try to limit all the money going into there. And then you could also put campaign contributions, and you could say, this is how much a campaign can raise. And if they don't spend all the money, they have to get it back or donate to the general fund or something or whatever, right? If you gave Congress the power to regulate campaigns, and you could even say, Congress shall have the power to regulate the time and funding campaigns, notwithstanding the Equal Protection Clause of the 14th Amendment. Congress shall have the power to pass legislation to enforce this amendment. Fairly simple amendment, and it would firmly place so that Congress sit around and you could get members of Congress to say, hey, you know what? Let's have campaigns for Senate and House last only 2 months. You could say you can only declare your candidacy 2 months ahead of time. You're going to campaign for the last 2 months, and you're going to spend this. You can only spend this many dollars per voter in your district. Right? Maybe they use that, and you could pass a law like that, and that would eviscerate. Now, why in the world did people like Scalia and Thomas just salivate over Citizens United? Because they knew that was going to influence the type of people who get elected. And because the type of people elected, that would influence who would nominate their justices and who would confirm their justices. The Supreme Court becomes most political and the most logic defying when it realizes it can shape its future. It becomes a political beast like there's no other thing. And so if you give the justices an ability to lock in their ideology for another couple of decades, they jump at the chance. And they go through all kinds of logic hoops to get there.
All right. Well, Landon, thank you very much. I am very much looking forward to, so that's actually at about 2 hours, and I think it was definitely worth every second of it. So thank you very much for your time, and thank you for doing this with us. So again, this is our first episode in a series the second Thursday of every month. We are going to be covering an element of American civics with Landon Noll. So Landon, was there anything else you wanted to say or plug before we get going?
I would ask that people go onto the web, open up, look up U.S. Constitution and read it. I was probably one of the few people in our city before I sat down to swear the oath of office to read it. And before I read it, I said, I'll hold the Constitution of the United States. I said, well, I better read that again just to make sure. And the Constitution of California, which was a big one read, and the city charter, right? I was one of the few people and I asked them for the oath because I wanted to see exactly what it said. The clerk said, well, you don't have to know what the oath is. You just repeat after me. You don't have to memorize it. Well, no, I want to know, because if I don't agree with it, I'm not going to swear it. You can't be in office if you don't swear it. Well, I want to mean what I say. So when I swore that oath of office, I meant it. I was one of those guys that in my desk drawer at my legislative desk was a copy of the Constitution, a copy of the state Constitution, a copy of the city charter. And I'd read those things. Those things matter. I wish that members, at a minimum, that our legislators and our president and our court would read the Constitution more often. But I'd ask you this: if you're listening to my voice, and you live in the United States, please take your time, just read the Constitution. It's not long, but it matters.
All right. And with that, I want to thank those of you who have joined us. Please remember to like and subscribe. And also remember, if you want to become a patron of the show, you can join us. We'll be having a hangout. Those hangouts are the first Monday of every month, and we've got one coming up reasonably soon.
Yeah.
Landon has.
Yep. And please become a patron. Up this votes. But our next civics thing will be on the June 11th.
Yep. June 11th.
And at 8 Pacific, 6 Pacific, 9 Eastern. And have we decided yet on what the next thing is going to be?
We haven't. We haven't. We had some ideas. We were thinking certainly the Supreme Court. We also could do either one of the branches of the legislative branch. Also, I do think actually the draft itself was mentioned tonight and may not be a whole. We'll talk about it. I've got some ideas. I wrote some down.
So maybe that's. I know the Supreme Court is going to be coming out with some cases, so it may be interesting to talk about what's on the docket of the Supreme Court and why you might want to pay attention to it and what that could demand to you, because there's a bunch of things the court is doing that actually matters and are very serious. So maybe the Supreme Court might be the thing to do next, but we'll see. Nice. That's probably that would be my vote, but we'll see what other people can say. Comments, you can give comments and see what's happening.
All right. Well, thank you all very much. My name is Nicholas Lamar Soutter. This has been In Time, and we will see you later.